everyone. In this video, we will talk about proper plaintiff rules and members' remedies by referencing to one case law, which is the case of appeal between 4 appellants from Facade Treatment Engineering Sdn Bhd FTE and 1 respondent from Great Light Builders Sdn Bhd GLBSB. So, what is the conflict? For convenience, the appellants in this judgment will be referred to as the plaintiff and the respondent as the defendant. This case is related to the unbundling of a business venture between 2 parties, which are GLBSB, which consists of all the 4 plaintiffs and the defendant, FTE, which consists only the 4 plaintiffs. In GLBSB, the defendant only holds 15% shares, which make him as a minority shareholder, while the remaining 85% share are held by the plaintiff, which give them more control over the business. The plaintiff claimed that GLBSB received advantage and financial assistance from FTE in helping them to make full or part payment of the outstanding amount due or payable by GLBSB to any of its creditors. And this has been acknowledged by both parties when FTE paid the outstanding sum on behalf of GLBSB. This also indicates that GLBSB received loans from the FTE. However, in accordance with it, GLBSB has failed to repay it. Hence, as the defendant also holds 15% share in the company, the plaintiff claims that the defendant is liable to repay some amount of the loan to FTE following his share proportion. This claim has led the plaintiff to bring it against the defendant, asking for recovery to be paid to FTE by GLBSB. So, the question is, what is the court judgment in this case? Does the plaintiff actually have the right to initiate the action towards the defendant? To know more about the answer, let's have Izzati to continue.
The Learned High Court judge dismissed the plaintiff claim on the ground that the plaintiff do not have the capacity to demand payment from the defendant, as the recovery of the loan is between FTE and GLBSB. During the trial, the High Court agreed with the defendant's submission that if FTE wants to recover monies owed to it by GLBSB, FTE should file the claim, not the plaintiff. The general rule is that the company has an existence and distinct from its shareholder. The impact of the doctrine of separate legal entity, together with the doctrine of privity, that is, only the parties to the contract can be sued and be sued, ensure that if the company suffers losses resulting from the breach of contract, only the company can sue the other contracting party. A member, being a separate person from the company, cannot sue the other contracting party. This rule is known as proper plaintiff rule. In this case, it is GLBSB that is liable to pay FTE. In this sense, it is undeniable that the plaintiff consider themselves to be FTE and that they believe that because they collectively control FTE, they have the right to sue defendant, which is actually a serious misconception. What may be seen from this case is simple. Firstly, that the loss suffered by a company is separate from that one of the shareholder. Therefore, they cannot recover damages just because the company in which they are involved has incurred damage. Second, a loss suffered by a shareholder as a result of a decrease in value cannot be regarded or deemed a personal loss and thus cannot be claimed or brought through a shareholder's personal action. It is clear that in order to redress a wrong done to the company or to recover monies or damages as alleged to be due to the company, the action should prima facie be brought by the company itself. However, in this case, there is no claim or demand by FTE against GLBSB. For the reasons stated just now, the Learned High Court judge dismissed the appeal by plaintiff to seek recovery of a sum of RM2,456,691.05.
Thank you, Izzati, for a great explanation about the proper plaintiff rule. So I can conclude that the proper plaintiff rule, which was established in the above case, does not permit any member of the company to proceed with legal action against the wrongdoer, and members are not allowed to take action on company's behalf against the wrongdoer. Plus, the company has the rights to take action as per its constitution. However, there is an exception to this rule where members can take action on behalf of the company. Before I proceed into the rules in the exception to proper plaintiff rule, let's take an example from the case of Tan Guan Eng and Ng Quang Ki and others in 1992, where members can take action on behalf of the company. In this case, a shareholder attempted to sue the company's director on company's behalf, as the company's director does things that are illegal. They are also known as wrongdoers. It was held that if the majority of shares are held by the wrongdoers, that is obvious that they are in control. A derivative action involves the wrongdoers in the name of the company. A representative action to enforce rights which are potential to the plaintiff. Its derivative in the right to bring the action is derived from the rights of the company, which are alleged to be infringed. Any member can bring derivative action regardless of whether he has member at the time the alleged wrongs were committed. So keep in mind that there are several rules in the exception to proper plaintiff rule. Firstly, if the action is ultra vires, meaning exceeding powers that are granted to an official authority, a member may sue. Secondly, if the wrongdoers are in control of the union's right, especially when there is a fraud on the minority, so an individual may take up the case. Thirdly, when a company should not be able to bypass a special procedure or majority in its own articles, where wrongdoers are the majority and control the company would not allow the company to sue when justice demands it. Fourthly, if there is an invasion of a personal right, personal rights where personal or individual rights of membership have been invaded and individuals sue in their own right. So I pass the next presentation to Maisara to talk about stationary remedies.
Now, let's talk about the remedies that are available for the members of a company. What is remedy? Remedy is the legal action that can be taken by the members, or also known as shareholder of the company, to protect their right or to avoid any unfairness that could happen within the company. For some cases, the law allowed the shareholder to take the legal action if they think the right as a member being compromised, or they can use it when they are in dispute with the director or the company. As I explained earlier in the video, our case is when the defendant was forced to pay for the company loss and took it as a personal loss, and this is such an unfair treatment towards the defendant. It is because, as we know, company shall be treated as a separate legal entity. So, this case can be categorized as operation under Section 346 Company Act 2016. Under Section 3461A, operation happened when the affair of the company is under director and is exercised by the director in a manner of oppressive towards other members of the company for his or their own self-interest, since they are the shareholder, members, or the dependent shareholder of a company. So there are many remedies available in the Company Act 2016. The first remedy available for the member is under Section 347, which is derivative proceeding. Derivative action is when a complainant may, on behalf of the company, initiate or defend a proceeding, and they shall be brought in the company's name. It is because the right for a people to do so on behalf of a company in common law is abrogated. Furthermore, the second remedy is under Section 348 of the Company Act 2016, which is leave of court. In this section, it is mentioned that with approval
it mentioned that a complainant may get an approval from the court or just leave the decision up to the court whether to decide this case and that shall be done under the oppression. So what is the process to do so? The complainant must give a 30 days writing notice to the director that mistreat them. And after that, if the leave was granted, if the leave is granted, the complainant need to bring and to proceed the case to the court within 30 days of the court leave granted. And then after those process, it is up to the court whether to decide whether the court wants to grant the leave or not. But in deciding whether to grant the leave or not, the court must take into action the good faith and if the prima facie exists on behalf of the company. But the most important thing, if the case is mentioned under this section, it shall not be compromised or settled without the leave of the court.
Okay, next, I will talk about the third remedy available under Section 349, effect of rectification. Inherent in the nature of derivative action, the controlling bloc in the company may frustrate the derivative action by causing the general meeting of shareholders to rectify the subject matter. To ensure that no injustice is caused to the minority, Companies Act 2016 maintains the position under the Companies Act 1965 that such rectification cannot frustrate the derivative action. Thus, the derivative action taken in the name of the company upon leave of the court can only be discontinued with the leave of the court. Last but not least, the legislature also recognized that the complainant will require assistance, and thus Section 350 provides that the court may make the following order when granting leave for derivative action by authorizing the complainant or any persons to control the conduct of the proceedings. Moreover, give directions for the conduct of the proceedings. In addition, the court also can order a person to provide assistance and information to the complainant, for example, expressions of the company's book and requiring the company to reimburse the complainant. Overall summarizations on the statutory remedies available to the company's member. Firstly, this decision is useful in clarifying that a deadlock situations will not prevent shareholders from still seeking relief under the common law derivative action. However, as noted by the Federal Court, Section 347, Subsection 3 of the Companies Act 2016 has abrogated the right of any person to initiate a common law derivative action. So moving ahead, there may be limited cases where this issue on common law derivative action will arise. There may still be the application of this decision in a multiple derivative action. Secondly, while the common law derivative action is abrogated, the statutory derivative action will then be the only method to bring such a derivative action. The statutory derivative action contained in Section 357 to 350 of the Companies Act 2016 would allow, among others, any shareholder of the company to seek permission to bring such a derivative action. There is no restriction of there being wrongdoer, control or not. So a shareholder, even in a deadlock situation or in a majority shareholding situation, will still be able to seek relief in the statutory derivative action. This is a remedy allows shareholders to bring an action when they have suffered a personal wrong. The courts will also examine any agreement between the shareholders and the directors to see if there had been any understanding or legitimate expectation. If there are any, the shareholders will have a stronger case for proving oppression. In conclusion, the law does give shareholders remedies
for when their rights are being infringed and those rights were illegally exercised. It will be also useful to know about what directors' duties are, such as promoting the success of the company, duty to exercise independent judgment, and duty to exercise reasonable care, skill, and diligence are amongst the core duties of the company directors. Finally, we have reached the end of our presentation. Now, let's review our presentations from the very beginning until the end, which is first conflict between directors and members, proper plaintiff rule, exemptions to the proper plaintiff rule, and statutory remedies available to members. We really hope that you have gained input from our video, and thank you for your attention. We'll see you guys on our next video. Bye bye.